Okay. Hello, everyone. Am I coming through okay for everyone? Mitch, can you hear me?
Yes.
Perfect. All right. Hello, everyone, and welcome to this Lawyers for Learners Know Your Lease workshop. This is being presented in conjunction with the Economic Justice Institute at the UW Law School. My name is Darius Redderson. I am the administrative assistant and program assistant to the Economic Justice Institute, as well as a legal studies major. And presenting here with me today is Mitch, the clinical law professor at the university, one of the clinical law professors at the University of Wisconsin Law School and the director of the Economic Justice Institute. Um, Mitch also runs our neighborhood law clinic, which specializes in a lot of lease specific things. So he is an expert on this area. So I'm going to turn it over to Mitch to take it away.
Thanks so much, Darius, and thank you everyone for being here today. Really appreciate your time and your intent in hoping to learn a little bit about your rental housing rights, specifically with respect to your lease. In addition to teaching rental housing law at the law school, as Darius mentioned, I also own a couple of rental properties, and I've worked as a rent abatement hearing examiner for the city of Madison. So I've got way too many years of experience dealing with rental housing law. What I've learned in all of those years is that it can be very confusing. So I'm here today to try to break down some of the confusion. And I just rattled off a lot of places that I've worked. And there is a disclaimer on this front slide that I just want to reiterate that what we're talking about today is information, not the official position of the University of Wisconsin, Lawyers for Learners, or the City of Madison, or anyone else. It's just informational purposes. If there's an opinion or anything here, it is solely mine and not and our employers or affiliates here. All right, so let's jump into knowing about your rights. So the first slide that I have for you here is a great big important overview. All right, so you've got a lot of rental housing laws that you should know about. You're going to want to know that the administrative code here in Wisconsin, it is a law, so it's here on the left-hand side of the screen on this slide. Wisconsin Administrative Code. It says ATCP. That stands for Agriculture, Trade, and Consumer Protection. They've got a whole host of chapters of law that apply to provide regulation to trade practices and consumer protection. But the one that you want to know is chapter 134. So you can Google this. You can do an internet search. You can look this up. It is online. It is free to look at and read. It's also very dense. And so we're going to go into some of the basics from it today. But if you don't get something, you have a question, and you are a person who likes to read, go online, go to the primary source. You can find a lot of summaries out there that sometimes may mis-summarize things. So you can go to the primary source and read what the law says. And the primary source here, again, ATCP Chapter 134. The next one that's there is the Wisconsin Statute, which is Chapter 704 of the Wisconsin Statutes. It is another chapter of law that deals with rental housing regulations. Those two together cover pretty much almost all of the laws governing leases and in the state of Wisconsin. And it says chapters, which sounds daunting, but in total, it's about 17 pages. So it isn't, that's both of them combined. So really good resource to go to the primary sources of law. That's true for this slide, for the rest of the slides and the details that we're going to get into. If you're renting a manufactured home, sometimes referred to as a mobile home, there's a couple more chapters that are listed right there, actually one chapter and one subsection of Wisconsin statute. So those are also good, very important to know, some additional rights for manufactured or mobile homes in the state of Wisconsin. So all of this, again, I'll say it a few times throughout, is about the state of Wisconsin. So if you're renting, in Rockford, or if you're renting in the Twin Cities, or you've rented someplace else, outside of the state of Wisconsin, different laws are going to apply. So this is a presentation for folks renting in the state of Wisconsin. All right. If you're not a reader, or you look at these laws and you find it that they're confusing, hopefully this website was going to break down some of that confusion for you today. But also there's some additional resources that we have here on this slide. The Tenant Resource Center has a very helpful website. If you're in Dane County, you can call them, you can walk into their office and get some great explanations about the laws that apply, and more sort of plain language, easy to understand, real people helping out, informing renters and property owners about rental housing rights. I pointed out already that ATCP stands for Wisconsin Department of Ag, Trade, and Consumer Protection. Well, it's not just a source of law, it's also an actual department. You can call them. You can ask them questions there. They also have a pretty informative website. So that's another good trusted government resource. Speaking of trusted government resources, Wisconsin State has a law library. It is downtown, just half a block from the state capitol, but they have a website as well. So you can walk in if that is convenient to you, but you can also go on the state law library's website anywhere in the state of Wisconsin and check out their resources. They have a lot of links to these same laws and some other good explainers. You'll hear us say throughout this presentation, consult a rental housing lawyer, right? So if there is a situation where you're like, I think that might apply to me, I think that that clause might be in my lease, or I'm concerned about what's happening, you can read it, you can go get help from these various different agencies, but you can also seek out a rental housing lawyer. Encourage you to do so. Really important to not just know your rights, but get help exercising those rights. We've also got a couple of other Lawyers for Learners videos that Darius and myself have done, and some others have done, that can be really useful in breaking down some of these laws. Okay. So again, remember these resources and these laws. We're going to go through some actual steps and things to know about when you are renting. So before you sign a lease, very important to read all of the documents. And so a lot of times we call this Know Your Lease workshop, but the lease is more than just the lease, which sounds sort of confusing, but the lease is all of the pages. So I see a lot of situations where you get a 2-page lease, and then you also get a 3-page attachment, and then another 3-page attachment, another 4-page attachment, and another attachment to that. And yeah, sometimes they're called an addendum. Sometimes they're called non-standard rental provisions. And so oftentimes all of the additional documents are 40 to even 50 pages. I'm seeing a lot of 40 and 50-page attachments to a 2-page or 3-page lease document. All of the documents are technically in the law called the rental agreement. So the lease, if you will, sort of simple terms, is just not simply the lease, it's the lease and all of the other agreement or agreements that are attached to it. Okay, so really important to look at all of those things. If you can, please, please, please try to find these documents beforehand. If you are a property owner and you're thinking about, hey, I would really like to do the right thing by my renters, you should post your documents along with photos or videos of the apartment that you're renting. It's just as important that your renters know the terms that you're asking them to follow as it is they know, what the living room or the bathroom in that apartment looks like. Arguably, it's more important that they know the terms. So renters, please, please, please try to get these rental agreements, and property owners should be providing them. Now, diving into some of these specific laws that we already mentioned, there are a couple of things that we want to point out to you today. So we'll go here before you sign a lease. And I'm going to hand it over to Darius in a minute, who will cover some important rights that apply during, and then I'm going to talk about after you sign a lease. But here are a few things to look for as you're about to sign a lease or you're looking for an apartment. So you cannot be charged a credit check fee if you provide the property owner or manager a copy of your recent credit report. So it has to be obtained within the last 30 days, but thanks to a recent law change, You can go to annualcreditreport.com. You can get a free credit report every single week from all three bureaus. This used to be that you could only request one a year, or at a much less frequent amount. You can now get them weekly. So since you can get them weekly, it's certainly possible for you to get a credit report for free and therefore avoid having to pay a credit check fee when you sign a lease or even fill out an application to rent somewhere. This is a big, big deal. A lot of places will charge 25 or even more dollars, which is illegal. The law also says that they can only charge you $25 if you don't provide a copy of your credit report, no more than $25. But you provide a copy of your credit report, and they can't charge you a credit check fee or an application fee like that to check your credit at all. That's the law that says so right there. If that law gets violated, you'll hear me say this over and over again. Talk to a lawyer, talk to the Tenant Resource Center, talk to the folks at the Department of Ag, Trade, and Consumer Protection, where you could file a complaint about that type of practice. Let's go to some more of these examples of things that you can need to know before you sign a lease. Your lease document should say within it, and you're supposed to know this before or at the time that you sign, who to call for maintenance. So when something breaks down, when it's really, really cold, and your furnace stops working, who do you call? What is their phone number? What's their name? What if it's Sunday? What if it's a holiday? Really important that that information is in your lease, and you want to know it before you rent, because you don't want to have to call later and say, hey, I need this information. The law also says that they have to notify you of someone who you can sue in the state of Wisconsin. And by sue, that's technically who you can give a lawsuit to or serve legal process. It's really important that they identify a person or company in the state of Wisconsin that can accept those papers, because if you do get into a dispute, you need to know who to give the legal complaint to properly. And so if that isn't listed there in the lease, that is, again, a law violation. And again, you're going to want to see a lawyer to help you work out what to do and how to find the right person or company. A lot of times properties are now owned by one company. You pay your rent to a second company. You might pay your security deposit to a third company. The maintenance is probably done by a fourth company. So it can be very confusing, and the leases are supposed to specify who it is that is responsible for getting legal service of process, or i.e. who you can sue. And they have to be someone in the state of Wisconsin. So if you're on a border area or anywhere else, really throughout Wisconsin, and the company is an out-of-state company, they have to designate somebody in Wisconsin that you can serve. Your lease needs to disclose before you rent any building code violations or any serious defects that exist in the rental property. Serious defects are things like lack of hot or cold running water, lack of heat, structural problems. So if you would step on the porch or a step and that step could give way and break, those things have to be disclosed whether they're building code violations or not. So if you find yourself moving into a place and you plug in an appliance, and suddenly there's a whole bunch of sparks and the power goes out, that is also a serious defect. If it wasn't disclosed, again, talk to a lawyer, talk to the Tenant Resource Center, call and or file a complaint with the Department of Ag, Trade, and Consumer Protection. That's really serious. It's really dangerous if you get into situations where you've got sparks flying or steps that won't hold weight, or no heat or no running water, no plumbing. Those types of things are really, really not just inconvenient, but could be very, very dangerous. So definitely exercise your rights by contacting the resources that we've provided here. This last one is really interesting. It's a new thing. What the full amount of mandatory charges are. I want to break that down for you. More and more people aren't paying their rent with a good old-fashioned paper check, right? We're paying it online. We're going to a portal, and the law says that the full amount of all charges need to be disclosed. The lease needs to say what those charges are. And what we're seeing is that a lot of portals, a lot of online payment websites, add on a fee of $2 to $5 or more. That needs to be listed. It needs to say if your rent's say $1,100, and you have to pay an additional $5 every single time that you pay rent because the only way that you're allowed to pay rent is through this online system, then that needs to be listed in the lease. It needs to say $1,105, or someplace say there's an additional $5 mandatory charge every month. Um, if utilities are separate, it needs to indicate that utilities are billed separately. If utilities are included and you have to pay an additional $100, then that needs to be listed. If you have mandatory charges, all of those charges need to be disclosed before you sign. So there should be no surprises as to what amount you have to pay every single month. So again, what do you do if that's not the case and suddenly find yourself paying more than you thought you would to the property owner? You know what to do. You call the Tenant Resource Center, the Department of Ag Trade and Consumer Protection, or you call a rental housing lawyer to get help asserting these rights. You can also try to point it out to the property owner on your own. But you can have help by calling some of those resources for further clarification. All right. I'm going to turn it over to Darius to talk about some rights to know while you are renting.
Hey, thank you, Mitch. So rights to know while you are renting. One of the first ones that Mitch had also talked about briefly on the previous slide was knowing who to contact. It's one of the mandatory disclosures that needs to be included within your rental agreement prior to renting the property. Those numbers that you get from that, very important that you keep those available because they include the contact people for maintenance, contact people for where your rent needs to go, who to contact if you have issues with paying rent, like Mitch had talked about, if the portals or online service that you submit your rent through goes down, who do you contact to submit it a different way or let them know that this is down so you are going to be late in paying it because of the system errors. Keep those numbers somewhere where you can access them. The fridge is a great place for that because you know where it is. You can usually attach them via magnet to that and it'll be right there. Nice, central, easy to access location. Keep them in your phone as well. Those numbers are crucial. They also should include contact information for the property manager or the landlord or the property owner, essentially the person responsible for the property. A couple of other things you need to keep in mind while you're looking at your rental agreement that impact you while you are renting. You cannot be retaliated against for reporting maintenance issues, calling the police, contacting a building inspector. If you have those issues and you need to call someone, it goes against those administrative codes from the Agriculture, Trade, Consumer Protection that they cannot do things like they can't raise your rent over that, they can't decrease your access to services, they can't try to, sue you or kick you out for possession of the premise or anything like that. And they also cannot make threats to take any of these actions against you. Where Wisconsin has some very strong anti-retaliation laws. If you need to contact someone, the property cannot retaliate against you for that action. You also cannot be evicted from a property if you or someone you live with on the premise is the victim of a crime. It's a very crucial aspect. A lot of rental agreements can and do include clauses about if you are party to a crime or a crime is committed on the property, there's actions that can be taken. But if you or someone who you live with is a victim of a crime, you cannot be evicted for that crime. It's very important thing to help protect those people in those situations. You also can't be made to be responsible for all of the maintenance. Management or the property owner, landlord cannot have a clause in there that excuses their liability for property damage. They also can't impose that liability onto the tenant. You, the property owner, is responsible for maintaining the property. So if there's anything in there of like tenants are responsible for, all of maintaining the electrical or anything like this, or they're liable for damages or injuries that result from something outside the tenant's control or blatant neglect from the property owner, those are not, those are things that are beyond your control. Or those are things that are not, that are illegal to include within a lease. Few other things, you can't be required to pay the attorney fees for the landlord if it comes to a legal dispute, or at least you can't have that as a required clause within the contract. So anything where it's like tenant is required to pay attorney's fees in the event of a dispute, that is an illegal clause. If you see any of these things, like Mitch has been saying repeatedly, contact the Tenant Resource Center or a rental housing lawyer. There's a lot of great resources. You can find lawyers through the Wisconsin State Bar Association or through the Wisconsin State Law Library. And you can also do quick Google searches to generally find most different types of attorneys in your area. But it's very important, if you see any of these things, contact someone, contact a lawyer who specializes in this area. Again, in the moment of being in the rental housing or being in the rental property, and when these things arise, it's not fresh in your mind usually that these are things. So there are a lot of great resources. Lawyers for Learners, as we have talked about earlier, has a YouTube channel where Mitch and I and other members of the Economic Justice Institute and the legal community have made short videos for these things. So if you're in one of these situations in like a couple of months, and also as Contessa has mentioned already in the chat as well, this workshop is being recorded and will be added to those resources. While you're in those situations and something comes up and you're like, I'm not sure about this, but I can't remember what the administrative code is or where to find it, you can go to those resources and you can find this video or some shorter ones that will also cover a lot of this stuff. So check those out, and if anything, know where they are so that you can find those in when these situations arise. I believe the next one we're going to be looking at here is going to be about the process of when you begin moving out of the property, both on time and if you plan to leave a property early, what your rights and processes are in those situations. And I'm going to turn that back over to Mitch to work on those ones.
Thanks, Darius. That's right, folks. Talking about moving out. So again, when you're moving out, a lot of times a property manager will say, hey, look back at your lease. There's a big list, one of those 50 pages of attachments has this big list of things that you need to do. And they may be right that there's a list of things that they want you to do. Whether or not those things are legal obviously depends. Again, you've already got the links or names to the laws here, but we're going to highlight a few things that a lease or any rental agreement cannot do. And so here's a couple of them that we see over and over. So first off, you got to get your security deposit back or an accounting of every single thing that's withheld. It has to be given to you or mailed. The law says delivered or mailed, so it can be hand delivered. They can send a Uber driver to give it to you, or it can be placed in the mail on the 21st day after the end of your tenancy, as they call it. A lot of folks will call me on the 22nd day and say, "Hey, Mitch, I didn't get my deposit back. It's been more than 21 days." And I was like, "How many days has it been?" I say, 22 days. And I said, "Well, it could still be in the mail." So it has to be mailed on or before the 21st day. So if you're waiting anxiously, please wait until probably the 24th or the 25th day to allow 3 or 4 days for mail, because it just needs to be mailed. When it comes, if you do get your security deposit back, whether it's in an email, but particularly if it's in an envelope, save that envelope, save records. Really important to save records, keep good records of things. So I should have mentioned at the top, when you get your lease, save it. Right. So ideally, you've gotten it as a PDF, right? You've gotten it as an electronic file of some sort that you've saved somewhere in your emails. If that isn't the case, take out your smartphone, take a picture of all 55 pages of your rental documents, okay? Really important to hang on to those. It's going to be one of the very first questions that a lawyer is going to ask is, do you have all the lease agreements and other rental document agreements? So please, please, please keep a copy of documents, take photos of the place when you move in. But when you move out, you cannot be charged for normal wear and tear. So even if you sign a document, it says it right here, but I just want to really emphasize this because we see this all the time, that says you have to pay $15 to replace any burnt out light bulb, or that you have to pay 125 or 200 bucks to clean the carpet. You cannot be charged for it, even if you signed it saying that you would. You cannot be charged for those things unless you caused damage beyond normal wear and tear. So if you went up and broke the light bulb, smashed it with something, then yeah, that's something that you'd have to pay for. But if the light bulb simply burnt out, as light bulbs do when we normally use them, or the carpet got dirty, because that's what happens when you walk on a carpet, you cannot be charged for those types of things that are normal wear and tear. Dust happens, drip pans get drips on them, ovens get dirty because you cook food in them. That's normal use. It has to, again, be above sort of normal usage to fall into the realm of things that you can be charged for. Again, your deposit has to, if anything is withheld, you need to be given a description of it. That description needs to be something more than simply cleaning and then an amount. If something says cleaning and it doesn't say what was cleaned, it hasn't, that written statement hasn't identified what the withholding is for, like what was damaged allegedly. So these are really important things, as Darius mentioned, really important rights. We have a couple of short videos about this, and again, lots of really important ability to assert your rights here, because you could be able to recover double your damages if there are illegal withholdings. So there's an incentive there, quite frankly. You need your security deposit back to be able to pay rent at your new place. And if it is wrongfully withheld, you might be able to get double. You can only do that if you understand your rights. So thank you again for knowing your rights, and then also look to the resources for help enforcing those rights. Moving on to our next bit. What if you move out early? Okay, so you bought a home, or you need to move for family, or for whatever reason, maybe you're even evicted. A couple of things here that I want to highlight. The property manager can charge for actual re-rental expenses, but cannot refuse to re-rent until you pay a fee. It's really important. I've seen this a couple of times just recently and a lot over the years, where renters are told that they need to pay $250, $300, $500 before the owner will start trying to re-rent. the law says that it's the owner's responsibility to try to what they call mitigate damages if you're going to move out and you're unable to pay. They can't stop or refuse to do that until you pay a fee. Okay, so they can't put it up front and say, we'll never re-rent your place unless you pay a fee. If you find a new renter, so you're going to move out and you find somebody who gets approved, your friend, a family member, somebody that you found on Craigslist, and the owner approves that person, and you did all the work, you did all the heavy lifting, advertising the apartment, showing it, and the owner hasn't actually advertised it or done anything other than, said, okay, we did a credit check and here's the lease. Then you can't be charged a giant, sublet fee, even if it's in the lease. Again, the owner has to mitigate their damages, and they can't charge for expenses that they didn't actually reasonably incur. Some bad news, if you will. If you move out early, you are generally still required to pay rent through the end of the lease if the owner is trying to re-rent the apartment. So again, if you don't find a subletter and the owner is trying to re-rent the place, even though you're not living there, you are on the hook for rent. This is true even if you get something like a 5-day notice that says pay rent or vacate. It sounds like it's an either or. It's not. It's pay rent, continue paying rent through the end of the lease, or vacate. And if you don't, it's usually then that can lead to an eviction. So even though there's an or in a lot of those notices, really important to know that moving out does not stop your liability for paying rent. Again, just driving home here, if your rental agreement violates any of these things, particularly 13408, you should talk to a lawyer, because your whole lease, if it does violate that code section, your whole lease is void. You could potentially move out early. You might even be able to recover your rent payments. So it could be a really, really important thing to do, to talk to a lawyer if you find that your lease violates that particular section. If you're moving out early and you have no written lease, a lot of people do not have a written lease. You still then have basic terms that the Wisconsin statute says that you need to give 28 days written notice before your next rent payment is due. All right, so that's a little bit complicated, but the Tenant Resource Center, Department of Ag, Trade, and Consumer Protection, rental housing lawyers all have a good explainer on that process for giving notice. It's in that statute if you want to read it yourself. So again, there are laws that apply even if you are, even if you don't have a written lease or your written lease is expired. This happens a lot, and then you stay on for several months afterwards. So these are just been a few quick important things to highlight. And we're going to drive home the resources again here on this next slide. Let's see if I can magnify some of these for you. So a couple of great resources again for renters in the state of Wisconsin. This Wisconsin Courts Systems Self-Help Law Center has a list of forms and some other resources. We mentioned the Tenant Resource Center quite a few times. Department of Ag, Trade, and Consumer Protection. Contact your local building inspector if you do have issues with, again, safety or any other type of structural issues. Really important to do that. If you can't find them, the Tenant Resource Center actually has this wonderful website to locate building inspectors to see if your city has one, because often they're listed by a city or county. Legal Tune-Up for Wisconsin can help you clear up some records issues. And again, we mentioned the state law library topics page. What about AI? Should you just ask, one of the many different AI services? I do all the time, and I find that they're wrong all the time. So be very, very careful. I've listed these resources here because they are trusted resources, governments or nonprofits that have been doing this for years, that have staff and volunteers who really care about this, who spend a ton of time learning these rights to share them with you all so that you can protect yourselves as you rent. So please reach out to one of these resources if you run into problems. And with that, thank you again for your time. We're able to take questions. And again, just if I answer a question, little disclaimer, it doesn't create an attorney-client relationship. Every case is different.
Okay, thank you, Mitch. I've seen at least 2 questions come in so far. Owen, earlier on when we were looking at rights and things while you are renting in the process of during the tenancy. What about mold? Like, what are the responsibilities of the um, landlord and tenants in regard to treating mold within a rental unit?
Yeah, that is a great question. So what about mold? So again, as Dries pointed out on his slide, so you're renting, the owner has a responsibility for maintenance and keeping your rental home habitable. What that means is that if there is mold growing behind the walls, that's a space that's, as Dries mentioned, is outside of your control. If there's a water leak that is causing the mold, because mold grows where there's wetness, that is something you want to notify the owner about. So notify the property manager, and if it isn't remedied, look for those building inspector resources on the slide that we just posted. Again, the Tenant Resource Center has a great list of resources there. Building inspectors, if you have one in your community, could come out and inspect and determine if the mold is something that is a code violation or not. Keeping good documentation is also super important here. So if you are getting any type of respiratory issues and you go see a doctor for yourself or your family members, keeping notes from those visits, keeping your medical records, providing those to the property owner, providing those to your rental housing lawyer, possibly even if it's severe, contacting a personal injury lawyer if it is getting to the point where you are incurring serious medical expenses. That's what personal injury lawyers are for, folks who advertise about car accidents and slip and falls and various other major physical injuries. If you're getting a physical injury from your home, it's not just a rental housing attorney who does evictions and security deposits, but it could also involve a personal injury lawyer is another good resource there. There isn't a quick and easy, oh, as soon as you see mold, do X or you get Y type of easy result here. It's one of those where document it, let the owner know, get the building inspector in there. Those are the first steps. Contact a lawyer, contact the other resources if that doesn't lead to resolution, and then everything is going to be pretty case specific.
All right, thank you. Another question we have here, can a landlord or maintenance staff remove or threaten to remove a screen door lock? Question specifically asked because the lease agreement sections about how/when entry to a unit is allowed.
Can a lock be removed? So you've got a law that says that an owner cannot enter without advance notice. So the law, again, the code that we talked about, ATCP 134.09 here, says that an owner cannot enter unless they're entering to inspect, to make repairs, to show the premises to future renters or purchasers, or if there's some emergency that they need to enter for. So they need to give notice, otherwise they can't enter. Typically, to change a lock, you actually need to open and kind of enter. So I would go to that particular section and see if you think you might have a violation there. And again, then run that by the Department of Ag, Trade, and Consumer Protection, who wrote these laws and who helps enforce these laws. You can file a free complaint with them. You can get some more information from the Tenant Resource Center. And if you feel that you want to talk to a lawyer, obviously reach out to a rental housing lawyer about that. So it could be a violation. You're talking about a porch. You get into interesting issues about sort of shared entries. So you could imagine, I can imagine at least a porch where one walks in and then there are multiple doors to multiple apartments. So essentially the porch is like an entry area that is shared. And you could get into a situation where that isn't actually entering a unit, but rather just sort of entering a common area. And then this law, I don't believe, applies to that. So it's going to depend again on a very case-specific, case-by-case basis. That's what I've got to say there. If they do change the lock and you had a key to it, you should get a new key. Again, most likely that is something that you could follow up with any of those resources on.
All right. Next question here. If the landlord wishes to evict a tenant, do they have to hire a lawyer?
No. Simple. There we go. I didn't think I'd find a simple, but that is a simple one. The law in the state of Wisconsin does not require a lawyer for either side to be able to go to court. People can represent themselves. As a matter of fact, in small claims cases in the state of Wisconsin, anyone can actually assist and represent anyone else, thanks to a law change in the 20 teens. Yeah, simple answer is no.
Nice. Where can a tenant get help for being charged extra, in parentheses, illegal fees for a Section 8 apartment?
Where can you say that again?
Where can a tenant get help for being charged extra fees for a Section 8 apartment?
Um, right. So if you're on Section 8, it means that you're working with a local housing authority. So Section 8 is a section of the federal code that gets people assistance in paying their rent. And it means typically, if you were here in Dane County, you'd be working with the CDA, the Community Development Authority in the city of Madison, or the Dane County Housing Authority in the county. If you're listening to this elsewhere, again, generally this has to go through a local housing authority. So you could reach out to your local housing authority, your sort of Section 8 worker, if you will, for additional assistance. But I would absolutely, I would go to any and all of these resources here. So again, your fees, your extra fees, if they're mandatory fees, that we covered that in one of the slides. That could be a violation right there of the administrative code. That you could report to the Department of Ag, Trade, and Consumer Protection. Could be something that you want to bring a complaint on your own about in court. You can do that again by contacting an attorney. So those are the things that you could do. I assume, all right, that you've already brought this up to the property owner. Obviously, trying to informally communicate and keep a record of that communication is always wise as well.
Actually, is part of our next question here. Before going to a lawyer, would you want to talk to the owner first to attempt to solve the problem?
Yeah, absolutely. But keep documentation of this. Highly, highly recommend, because if things don't get worked out, the thing that will happen in a court case is that you'll be asked, when did you notify the owner? How did you do it? What did you say? What did they say? And if you do this orally over the telephone, or you do this in person, or you do it, the record's gone. So I really suggest emails for this. Text messages are sort of a second best because you can lose text messages pretty easily. But emails are a wonderful way to try to work things out informally. A lot of property owners do want their customers to be treated right and will respond to concerns. But you have to articulate them and let folks know. So yeah, absolutely try to work them out. Do get documentation of it.
All right. Next question. What do you recommend to do about landlords who don't seem to be aware that evictions must go through the court?
So in addition to everything else we've said here today, the resources, I'm going to add one more. If you are illegally locked out, that means, or you have some sort of utility shut off, right? So if the property owner doesn't know that they have to go to court, in addition to calling a lawyer, you should be able to call the police. Generally speaking, the police do not intervene in civil cases. However, a lot of the police and sheriff's officers that I've talked to about rental housing disputes know enough that they will restore, not all of them, but it's possible that they will restore you to possession, i.e. they will let you back in or get the owner over there to let you back in and inform or re-inform the property manager that the only way to kick somebody out is by going through the court system. So yeah, contact a lawyer because that's very, very illegal. But you might also be able to get immediate relief by contacting the local police or sheriff's department who might, and I want to emphasize might, intervene and help you out with that.
All right. That goes into the category of, I believe, self-help evictions, which are very illegal within the state of Wisconsin.
Right.
Next question. If medical waiver animal dies, can renter get another one and then contact the management company to update the name of animal and provide vet record? Or does the renter have to contact management upon death of animal to have get a new medical waiver policy form to start the process approval over from
Wow.
a no pet complex specifically.
So this is a great and really detailed question, and it highlights something that we didn't mention that I wanna quickly say, which is that if you feel like you're being discriminated against before, during, or after that you rent, there are a couple of really great resources in addition to those that we've already mentioned, which will hopefully also tell you about these resources. And they are the State Department of Department of Workforce Development, their Division of Equal Rights. That is where you can file what Wisconsin calls an open housing complaint, which is Wisconsin's equivalent to fair housing law. If you're in a bigger city like the city of Madison, Madison has a division of civil rights where you can file a housing discrimination complaint. So if you feel like you're being discriminated against because of any protected status whatsoever, or your disability is not being accommodated, you can contact those folks. You can file a complaint there for free. They can explain rights like this question with respect to any of the anti-discrimination laws that we have throughout the state of Wisconsin for rental housing. And so it's going to depend a little bit on what your agreement says with them. I believe that in general, you cannot be denied or taken adverse action against you because you have some type of either emotional support animal or service animal, and therefore communication is always good. So I think if I remember the question correctly, it was, do you communicate this to the owner? It's always good to have communication, even though it would obviously be terribly sad if your medical animal passed away. Letting them know you've gotten a new one, probably on a good idea, so they don't think it's just some additional animal that's a pet as opposed to a medical emotional support animal or service animal.
Okay. Next one. Is the management company of a property legally required to notify current residents that the apartment complex for new renters is now a Section 8 property? And if not, how do you find out if your units or if your property is now qualifies for Section 8 rent?
Um, to the best of my knowledge, so when you get into Section 8, you're layering on top federal regulations because it's a federal set of laws on top of the state regulations. And to the best of my knowledge, there isn't a requirement that the management company notifies residents living in an apartment complex that they're willing to accept Section 8. As a matter of fact, I just mentioned those discrimination resources. And so in Wisconsin, receipt of rental assistance is a protected status, particularly in Dane County. They've gone even further and said specifically and explicitly the receipt of Section 8 is a protected status. So if you are not getting, the same treatment as other renters because you're receiving Section 8 benefits, that could be discrimination. If so, the classic one is a renter saying, or excuse me, a property owner saying, we don't rent to people who have Section 8. And in Dane County, that is explicitly illegal. In Wisconsin, they call it the receipt of rental assistance. But those types of things could be discrimination claims. So that's why I don't believe that there's a requirement that they need to notify people, because quite frankly, every property, they might not have filled out the paperwork to accept Section 8, but every property could accept Section 8 sort of vouchers or other types of government rental assistance. So that's what I've got on that.
Right. Can the landlord charge a pet fee for emotional support animals?
No. Again, so DCR, that's the Division of Civil Rights in Madison, the Equal Rights Division over at the State Department of Workforce Development. Those are the folks you want to talk to. Disability Rights Wisconsin is another great resource there. But my understanding of the discrimination law there is no.
All right. And I think that is the last of the questions that we've had come in so far from the chat.
All right, folks, we've got just a few more minutes. If there's anybody else is thinking of any other questions, please type them into the chat. And again, please avail yourself of the resources that we've mentioned here today and that are in these slides. Really important. I know there's just so many rights and problems come up. I know when I was renting, I had sewage fall through my ceiling, it was a very rough week. And I didn't know what to do. And I ended up calling the Tenant Resource Center and got some assistance and went on to become a rental housing lawyer to hopefully break down some things and explain them back to everybody else because I get it. It's confusing, it's stressful, and literally when the sewage falls from the ceiling, you hope you have those numbers handy as to who to call and what your rights are. So please, please, please know that you do have rights, know that you do have people that you can reach out to. Don't trust it to AI. Call a real government office or a real nonprofit and a real rental housing attorney and dig into it because every case is going to be a little bit different.
All right, and once again, I just want to say this workshop has been recorded and is going to be going up on the Lawyers for Learners YouTube channel eventually here. They also have a bunch of shorter format videos as well that are easy to take in and skim through to find the topics you're looking for. Utilize those resources, utilize the resources again that Contessa just posted back into the chat here as well with the links there. And thank you everyone for joining us today. Seeing no more questions. Everybody have a great rest of your day.